Everybody, welcome to the third session for the Idahoans and Openness in Government. It's been a real privilege to work with our team here in terms of organizing and just promoting government transparency. I think one of the big things as I kick it off here is, for all of you in the room, there will be question cards. Betsy's going to go over this in a minute. For those of you online, the email address works again. There's more people watching online than here in the room today. But I think one of the biggest things from the themes of the last two sessions is just we're at a time where trust in government and trust in the public sphere is always a challenge. And so I can say my counterpart who's about to come up here, Controller Brandon Wolf, and I have both worked diligently to continue to try and build trust. And I think that IDOG is an amazing partner in terms of us continuing to build trust in government, whether that's open meetings, access to public records, just transparency in terms of financial transactions, which hopefully Brandon will mention some of their recent success. It really is a partnership. And as the stewards of this work, it's important for us as government officials to also participate in promoting this. So this series is a great opportunity for that. And to kick things off, I'm going to turn it over to my good friend and partner, Controller Brandon Wolf.
Thank you, Secretary McGrain. It's great to be with you this morning. I know we have a lot here in the room, and I know Betsy will probably share the numbers, but we have, I believe, close to 200 that are participating online. So welcome, and thank you for participating. I'd like to introduce kind of the lead behind all this, Betsy Russell. For those that may not know, Betsy retired, and it's been 3 years. Does it seem like that? 4 years? 4 years? Time flies. And Betsy, a long storied career in journalism. So the last 5 years of her career, she was with the Idaho Press. And prior to that, 27 years with the Idaho Spokesman. Several of those years were in Coeur d'Alene in Spokane area, North Idaho. But a majority of that time was always focused here on the Capitol. She also had several years with Idaho Statesman. And she was the former longtime president of the Idaho Press Club and the Capitol Correspondents Association, and she is still the founder and president of the IDOG, the Idahoans for Openness in Government. And so with that, please join me in welcoming Betsy Russell.
Welcome, everyone. Idahoans for Openness in Government is a nonprofit coalition for openness in government that's affiliated with the National Freedom of Information Coalition. There's more about us at our website, openidaho.org. Our mission is to foster open government supervised by an informed and engaged citizenry. We believe that we all benefit when the public, the media, and government officials are fully aware of the public's rights to access government information and observe the conduct of the public's business. You received a couple of handouts when you came in today if you're here in the room. One is this flyer about all 4 of the sessions in this series. The other is a little bit about IDOG and how you can join us and support us in our efforts if you'd like to do that. We welcome you to submit questions during our program today. For those in the room, please write your questions on the cards that you have and hold them up, and a volunteer will bring them up to the moderators to be posed to our presenter at the end of his presentation. And for those online, you can email in your questions to idogquestions@gmail.com. That's idogquestions, all one word, @gmail.com. And I would like to acknowledge that in addition to all of those in the room today, we have 4 times as many people participating online. We have more than 300 people participating today, and I think that's pretty awesome. Also, a full recording of this session, plus the full slide deck, will be posted on IDOG's website within a few days after this session. We're a volunteer organization, so I'm not setting a firm deadline, but it will be up. I would like to thank our partners in this effort, who include our state controller, Brandon Wolf, our Idaho Secretary of State, Phil McGrain, the Idaho Association of Cities, the Association of Idaho Counties, the Idaho Press Club, Idaho Public Television, Attorneys for Civic Education, the BSU School of Public Service, and the University of Idaho College of Law. If you are an attorney, thanks to our partnership with Attorneys for Civic Education, you can receive continuing legal education credit through the Idaho State Bar for participating in this workshop today. Please sign up on the list and back if you're attending in person, or if you're participating online, follow the instructions that you received in an email from the bar, or email Teresa Baker at the bar, and she'll connect you with that. And if you're not an attorney, don't bother signing up on the CLE list in the back. It won't do you any good. We are very fortunate today to be joined by Andy SNOOK. Andy serves as General Counsel for Idaho Governor Brad Little and has served in that role since the summer of 2024. He initially joined Governor Little's office in 2023 as the Associate General Counsel. Prior to joining Governor Little's office, Andy spent nearly 15 years in the Idaho Attorney General's office, providing legal advice to numerous state agencies, boards, commissions, and elected officials. Overall, Andy has served in public service here in Idaho for nearly 2 decades. He earned his law degree from the Syracuse University College of Law and his bachelor's degree from Idaho State University. He is a fifth-generation Idahoan. But before we hear all about the law from Andy today, we're going to call on some of our audience members to play parts in an interactive skit about the Idaho Public Records Act. Portraying the role of Ernest, the rookie reporter, will be Senator Jim Guthrie, chairman of the Senate State Affairs Committee. Come on up, Senator. And portraying the role of undertrained and overly cautious deputy clerk is Christina Lords, editor of the Idaho Capital Sun. Come on up, Christina. And Idaho Secretary of State Phil McGrain will be playing the role of the referee. Actors, take your places.
Oh, how the tables have turned.
I turned that one on for you. Are your mics on? Okay.
Well, good morning. How are you doing this morning?
Pretty good, and you?
I'm doing pretty good.
Well, before you make your request, I'm going to give a little scene setter here. Oh,
Pardon?
sorry. I'm going to give a little scene setter for you.
Oh.
So in this scene, we are meeting Ernest, a rookie reporter. Ernest, please wave at our audience. And undertrained and overly cautious deputy clerk. Undertrained, please wave at our audience. Ernest has received a tip that the county road superintendent's property has been assessed at 30% less than a smaller property right next door. Very curious. It's a heck of a story if it's true, but Ernest is a bit shy and doesn't want to look nosy. He's also afraid that if he reveals why he wants the assessment, he won't get the document he needs. Undertrained also thinks Ernest is being nosy, and she's afraid that if she makes a mistake, she'll get fired. Okay, action.
Good morning, and thank you for welcoming into your office. I appreciate it.
I'm doing great. How are you doing?
Well, fine, I guess. I was kind of wondering if you could, oh, by the way, I just love the way you've decorated your office. It's really nice. But some question on some records. I'd like to get a copy, of the county superintendent's, what do you call it? You can probably help me here, but an assessment. Maybe a tax bill, maybe his tax bill. Do you think I could get those things?
Well, that's kind of personal. I can't do that. I'd get fired.
Just kind of checking out a rumor, and you know how those go. And I've got a job to do too, or I might get fired. Aren't those, public records?
Well, why would you want to be looking at somebody else's tax records?
Time out. Roughing the constituent. 15-yard penalty.
You took way too much joy in that, I think.
There are two important points here. First is that a public record is a public record. It's none of the government's business whether Ernest wants to use it for wallpaper, print it in the newspaper, or to challenge his own tax bill. In fact, Undertrain violated the public records law by asking Ernest why he wanted these records. The statute specifically says that the custodian of public records shall make no inquiry of any person who applies for a public record except to verify the identity of a person in accordance with the section of Idaho Code that allows you to see the record about yourself, or to verify that the record will not be used for a purpose of telephone or mailing list, or to prevent disclosure of certain personal information collected for driver's licenses or as otherwise provided by law. The custodian may provide the requester information to help them narrow the scope of the request or to help them make the request more specific. Also, the person seeking the record may be required to make a written request and to provide their name, a mailing address, and telephone number. Second, if Undertrain gives Ernest the records he asked for, he's following the law and can't be fired for following the law. Property tax assessments and bills are public under the general authority that citizens have a right, can't review the work of public servants if they can't see the work product. There may be other public records that may seem a bit personal, but they are public records and citizens can see them. Examples include monthly bills, itemized for use of government credit card, contracts with employees and with suppliers and service providers, names of employees, lists of people in arrears on their tax bills, and agency check register. If you're spending public money or managing public agencies, the public has a right to see what's going on.
Hear, hear, and how about a round of applause for all three of our actors? Now we'll hear from Andy Snook about the nuts and bolts of the Idaho Public Records Act and how we can all make it work. Andy?
Okay, good morning. Hopefully folks can hear me all right. If I sway away from the microphone or anything like that, try and nudge me a little bit closer. So a couple preliminary matters. As Betsy kindly introduced me, I am an attorney, but I'm not here today as your attorney. So this isn't me giving you all legal advice on how to go about your jobs. I'm here to walk you through the IDOG PowerPoint on public records. Along the way, share with you kind of my views, my experiences. Those are my kind of personal views and experiences based off, 15, nearly 20 years, I guess now, years of working with the Public Records Act, the Public Records Law. So kind of view me as your tour guide as we go along here. Depending on what role you work in, you've either got an assigned attorney or you have access to one. So that's, standard attorney disclaimer there. Also, as another preliminary matter, I need to give a little bit of credit to Brian Kane. Brian's not here today, but Brian and Betsy are really the ones that do the heavy lifting in putting this PowerPoint together. I've made a few adjustments along the way as I've helped out over the last few years, but they certainly deserve the credit for putting this together. Another word on resources, right? Seminars like this are a great resource. As Betsy mentioned, this presentation will be on IDOG's website. I encourage you to utilize this presentation as you go forth and go about your job dealing with public records. The statute is pretty user-friendly, so if you are going to work in the space of public records routinely, I would encourage you to be familiar with where to access those statutes. Maybe you're a little bit more old school like me and you print them off and dog-ear them up and highlight them and those kinds of things. I would encourage you to do that. There's also another long-standing resource out there. It's the Public Records Manual that's maintained by the Attorney General's office. And again, if you're going to be working in this space, that's freely available. It's online. Again, you can print it, download it, get a copy, access it online, and I'd really encourage you to do that. So even folks that have been working in this space for a decade plus will still refer to that manual quite frequently. So there's that. And I guess maybe the final preliminary matter here is,
Andy, I've had a request from one of
Uh-oh.
our online listeners to please speak up.
uh-oh, okay. Well, we'll try. So final preliminary matter, we're talking about the Public Records Act. So we're not talking about litigation or discovery. So if you find yourself in litigation responding to a discovery request, the Public Records Act is really not going to help you. But again, if you're in that situation, you should be working with an attorney. But I just offer that caution because I've seen agencies over the past, some kind of piece of discovery lands, and they say, well, that's exempt under the Public Records Act. Public Records Act kind of no longer applies once you're in discovery. So again, just trying to, I guess, set the expectation around what we're talking about today. So, all right, that's got to be enough preliminary matters. We'll get into the slides here. So our first slide is actually borrowed from the open meetings law, but it's a good foundational slide to sort of set the tone for, what we're talking about. And Secretary McGrain, Betsy talked about this in our intro, about transparency. So I've broken this kind of out into two parts. The first part talks about citizens not yielding their sovereignty to state agencies that are created. And the second part talks about public business should not be conducted in secret. So as I look at that, the first part to me really just means government always remains accountable to the people, okay? And the second part is business should be conducted out in the open. You'll hear more about that when you hopefully attend the open meetings training later this month. But the way I've heard it described well by folks like Brian Kane is if there is a void out there in the public, it's going to get filled by some kind of speculation. So if the public doesn't know what kind of business you're conducting as a public agency, or why you're conducting business a certain way, or why you won't produce certain records, they're going to start to reach their own conclusions. And in my experience, that speculation is almost always negative, okay? So compliance with the open meeting law, compliance with the Public Records Act is a good way to just build public trust in your agency. So that's kind of our introductory slide there. And I think that covers all my notes. I apologize, we've got a lot of notes in the margin. Some I'll touch on, and some we'll probably just have to skip over so we can stay on schedule. So, next slide talks about definitions. Definitions for any statute are important because however the legislature chooses to define a term is how that term is going to be applied for purposes of that law. So, an extreme example, if you have a piece of legislation and it defines up as down and down as up, might not make any sense to you, but that's how it has to be applied for purposes of those statutes. So we're going to talk about several definitions today. None of them are those extreme examples of up being down, down being up, but they're very important as you work through the Public Records Act. We'll kind of start with the definition of custodian that's provided in the Public Records Act. And it talks about that person having custody and control of a public record at an agency. And again, we'll talk about some more definitions here in a minute. But this idea of a custodian has become even more important over the last few years. It hasn't always been the case that an agency's been required to have a designated records custodian. I imagine a lot of you that are here today or watching online probably are the designated records custodian for your agency. And that person serves an important role because they're the main point of contact for the public and that agency when it comes to requesting records. So your records custodian, they need to have a familiarity with the Public Records Act, and more importantly, they need to have a familiarity with the types of records that your agency has. Not going to spend a lot of time on writing or state agency. The quick takeaway is they are both very broad. So writing under the Public Records Act is pretty much anything. So things written down on a napkin, if they pertain to conducting public business and they're on site, that's a public record. So writing, physical, electronic, writing is very, very broad. State agency, that's at the state level. Pretty much anything you can think of from a board or a commission, elected official, an officer, they're going to be included in that state agency definition. We've also got definitions for public agency so that we can incorporate local governments as well. Public official, again, like I said, is kind of anyone under the umbrella of government is going to be subject to the Public Records Act. And now that we get to the definition of public record, we will spend a little bit more time on that because that's obviously what we're here to talk about. So again, this is any writing, and as we talked about, writing is extremely broad, related to the conduct or administration of the public's business. Okay, and that's an important phrase because there will be some things in the custody of an agency that don't necessarily relate to the conduct of business. And so the example that we've kind of offered over the years is maybe incidental personal use of an email. So maybe my spouse emails me and says, I can't pick up the kids from daycare. I need you to grab the kids this afternoon. Okay? It doesn't have anything to do with how the agency operates. It might mean I have to leave a little bit early, but that really doesn't qualify as a public record. So there may be things, within the files or offices of public agencies that are for folks' personal use possibly, or they just don't relate to the conduct of the state's business. So that's an important distinction. I wouldn't call it an exception. I think it's just the scope of the definition. And as you can see there with the rest of that definition, there is a carve out for personal notes created by a public official, unless those notes have been shared with somebody else. So to me, that's an interesting example of a document where the nature of that document might change over time. So on day one, maybe it's just your personal notes and it's not subject to the Public Records Act, but in a week or 2 weeks, when you share it with a colleague, now it's a public record. So just something to be aware of. We'll spend a little bit of time talking about the definition of a resident, but we'll also in later slides talk about how that is applied in the Public Records Act. This is a relatively new addition to the Public Records Act, 2024, 2025. This definition was provided. It's a pretty lenient standard, domicile in Idaho for 30 days. So, that's not all that burdensome. But as you'll see in the next few slides, whether you're a resident or non-resident is going to be very important in terms of the agency's required response timeline and then the fees that you might have to pay as a resident versus a non-resident. But before we get to that, just kind of another foundational slide on the right to examine public records. If something is indeed a public record at a public agency, it's available for copy and inspection by any person, whether they're a resident of the state of Idaho or Texas or Florida. Our public records are available to the public. As we work kind of through those bullets, just real quick, agencies certainly can make delivery of public records via email. That's pretty much the standard method of delivery these days. That's the most convenient for both the agency and the requester, but you still have, I think, folks from time to time coming in to get hard copies and that kind of thing. So in terms of examining public records, this again is something that I've not seen very often over the years, but it is possible that maybe a requester, they don't know exactly what it is that they're after. So maybe they want to come in and review a stack of documents, and then at the end of that review, they say, I'd like a copy of, these 12 as opposed to the 100 they just reviewed. Like I said, I have not seen that very often. We could spend a whole lot of time on hypotheticals around that, or if you have a question on that, certainly feel free to submit it. because I've certainly heard plenty of discussion about the examination of public records. But again, I just don't see it all that often. So we'll see if we get a question on that later. So now that we've talked a little bit about, what is a public record, how do you submit your request? What does that process look like? Under the law, the agencies can require that you submit those requests to the designated records custodian. And certainly, my experience, that has been the best practice for agencies. It keeps things coordinated, keeps things from getting lost, right? So you really can't just submit a request to anybody in the agency, which is a good thing. Now, if you do, and that isn't the right person, hopefully they're redirecting you to where you should be submitting that request. But, if you slip a Post-it note underneath my door, I'm probably going to redirect you to where that needs to go, but I'm not going to treat it as a public records request. One of the themes you'll kind of see on this slide, and as we discuss how to submit a request, is specificity. And I'm probably going to mess that word up as we go on here, but it is your friend as a public agency, and it is also a friend of the requester. The more specific folks can be about what it is they're after, the easier it's going to be for the agency to locate those records, locate them timely. Everybody goes on with their day. Date range is very important. It's probably one of the most important things that I've seen over the years in terms of how to characterize your request. Because if you send a request that says, I'd like all the emails between so-and-so at the agency and so-and-so in the legislature, depending on how long those folks have been in office, it could be a year's worth of emails, it could be 30 years worth of emails. So date range is very important. So we'll talk a little bit more about that later in terms of how to, perhaps narrow requests and what public agency staff can ask and offer and what they can't. We saw a little bit of that in the skit. But specificity and date ranges are a very good thing. I'm going to set my phone out just so I can see if I'm keeping us on time or not. I promise not to take any calls. Let's see. So another slide on submitting that request, because again, I think it's kind of that foundational interaction between the requester and the public agency. Under the law, there's got to be sufficient detail so that staff can find it with a reasonable effort. And some folks look at that reasonable effort language and maybe they shake their head a little bit. Certainly we've had requesters, or I've seen requesters be frustrated that the agency isn't moving fast enough, even if they're within the time frames, right? Because it might seem like a very simple request. You show up, public agency, I really only want this one document. Why is that going to take 24 or 48 hours? And in my experience, the answer is because public records custodians and the folks they work with, that public records are one of 1,000 different things that they do every day. So there are statutory timeframes, and we need to meet those. But within those statutory timeframes, a little bit of patience goes a long way. So the second bullet was also mentioned during the skit by our referee. So we really don't do anonymous requests for public records in Idaho. I don't know the lengths we'll go to actually verify your name if you provide a fictitious name. But you do have to identify your name, you do have to provide contact information, you do have to now provide a declaration about your residency. But the reason that contact information is needed is we need to know where to deliver these records, and we also need to know how to contact you if we need to clarify something about your request. So if you're submitting a public records request, don't get too frustrated if you've got to do name, email address, telephone number, those kinds of things. On the one hand, there's a very practical reason for that. On the other hand, it's in the law. So again, going back to some of the comments made during the skit, the public agency, you really cannot ask why. So when somebody submits a records request, the response back cannot be, why do you want this? That's in the law. My guess is it's intended to protect requesters and avoid a chilling effect. I think a lot of people would be less likely to submit a request if they felt like they were being interrogated about why they were submitting their request. Okay, so we can't ask why folks want something. If they offer it, that's entirely up to the requester. So if you have a requester contact your office and say, I'm looking for these things because I'm working on a research paper about X, Y, and Z, there's nothing wrong with that. You haven't asked the why. They've offered it, that's fine. You can factor that into developing the request and then identifying the responsive records. Mailing lists are going to pop up a few times on here. I'm not going to spend a whole lot of time on mailing lists. If we get questions about it, happy to talk about it, but mailing lists have been a frustrating one over the years. So, like I said, maybe we'll get a question and we can spend a little more time on it. So we can't ask why when a request comes in, but we can certainly focus on the what. What is it exactly that a requester is after? Going to make your life easier as a public agency. It's going to make their life easier when they either, get 50 responsive records or 500 records that might be responsive, but really aren't what they're looking for. Okay, so there's nothing wrong with having some back and forth with the requester to talk about the scope of their request. Again, going back to that specificity, because if you can get a good request that is specific with a identified date range, okay, that request is going to be processed a lot more efficiently. It's going to save the agency time. It's probably going to save you as the requester time in reviewing the documents once you receive them. And as we'll talk about here in a slide or two, it's probably going to save you money because at some point you could start incurring costs for your public records request. Okay, so we're going to talk about residents first when it comes to, we've listed this as the copying fee restrictions, but it's more than just copies. It's staff time and a few other things. Up until a few years ago, these applied equally to residents and non-residents. So with the change in the law, 2024, 2025, these things remain the same for residents, okay? If you're going to charge a fee as a public agency, it can't exceed your actual costs, okay? We'll talk a little bit more about that as we go, but I kind of like to caution agencies sometimes in the past that this is not a revenue stream, right? Because some agencies get a lot of public records requests, and perhaps they're easy to fulfill after they've, got a rhythm with certain reports or things like that. But it's actual costs. The law allows you to sort of make yourself whole as an agency, but it's not a moneymaker. So, not a moneymaker for agencies. When an agency calculates staff time for residents, for a resident request, that's got to be calculated at the lowest rate of pay for the person capable of fulfilling their request. You get the first 2 hours for free as a resident, and you get the first 100 copies or pages free as a resident. As a public agency, you are allowed to aggregate requests. So if you get the same request or extension of a request every 3-4 days or every week by someone who's trying to avoid the 2 hours or the 100 pages, you can count those together. But it's something that you need to be consistent about as well. And when it comes to potentially charging a fee to a requester, an agency can ask for advance payment. Now that's typically if it's going to be a significant amount of time, right? My experience, the vast majority of public records requests are fulfilled within the initial 3 days without a cost because it takes less than 2 hours or it results in less than 100 pages. But while it may not be as common, fees are certainly somewhere that can create a lot of friction with the requester. So it's definitely important for us to talk about. So that's kind of the landscape for fees with respect to residents. Now, non-residents, slightly different story. So again, these are folks that haven't been domiciled in Idaho for the past 30 days. So they still get some of the same, benefits. You still can't exceed the actual costs, but you're no longer limited to the lowest rate of pay for this person capable of fulfilling the request. And there's no free 2 hours or 100 pages anymore. So basically with non-residents, the meter starts running as soon as the request is finalized. But again, you're still capped at actual costs. So not going to be a revenue stream. When a non-resident shows up with a request, the standard fee can't be $1,500. You still got to kind of work through that process. Be consistent. Specificity is good, consistency is good. So we've talked about submitting requests, talked a little bit about fees. What does the public agency do in response to those requests now? So again, we're going to break these slides into residents and non-residents. On our resident slide here, as you can see, and if you've got any familiarity with public records, you're familiar with the 3 working day response time. That is the standard, and frankly, that I think is kind of the gold standard. I don't think there's anywhere else in the country that has as quick of a response time as here in Idaho. Longer requests can be extended to 10 days after the initial request. I've seen agencies get tripped up here a little bit when they try and do 10 additional days for a total of 13, which you don't get. So it's 10 days from the initial request if additional time is needed. So agencies certainly have a lot more success, though, with that public trust and confidence if they can fulfill those requests in that initial 3-day period. So if you can fulfill it within that initial 3 days, that is definitely proven to be the best course of action. Agencies tend to run into a little bit of trouble if they're merely sitting on something because they can say, we can issue the 10-day. You kind of need a good reason, or else you're going to start to erode that public trust a little bit. Now, there are going to be exceptions to every rule. You may have an extremely unique or voluminous type of public records request. Maybe you're a small agency, and it is literally impossible for you to fulfill it within 10 days. When I have seen those cases in the past, agencies have done well to stay in communication with the requester, explain what's going on, talk about narrowing the request, but some of them just are voluminous, and it might be that research project where it's like, hey, we're after a lot of stuff. But if you communicate early, you communicate often, perhaps you make a rolling production as things become available, that's going to go a long way to maintaining public trust and having that requester sort of just be on the same page, right? So again, 3 days, 10 days, that's the standard. If you're looking at something that's going to need to go beyond 10 days, that's something that you need to be talking to other folks in your agency about so that they're aware, and hopefully also working with your attorney. A couple other things from this slide. You do have to sort your exempt versus non-exempt materials out from what's responsive. So I may have a stack of 100 documents that are responsive. If only 20 of those are exempt, then those are the 20 that get pulled out and the rest are produced. So you sometimes see that with a report. There may be a report with certain provisions that are exempt from public disclosure. Those get redacted or withheld, and the rest of the report goes. Bonus points for anybody that identifies all the different types of days that we're going to talk about today. You wouldn't think there'd be very many, but there are. So let's talk about non-residents. Again, new concept, treated a little bit differently than residents. So now with the non-resident, agency's initial response time is 21 days. Can get up to 35 if you need an extension. And the nuance there, right, is it's not a typo, it's 21 days now. We're not saying working days, so the default becomes calendar days. So just kind of keep that in mind as you're setting your reminders and setting your trackers. This is, again, relatively new, and so agencies, I think, are still getting used to how to handle and work with non-resident requests. But that is an important difference, right? Deadlines, timelines matter. But the remainder of the slide is the same in terms of narrowing the request, sorting exempt material out, producing the rest, those kinds of things. All right, so you've submitted your request and the timeline is approaching, or perhaps it is passed. You know, how does this request you've submitted get responded to? If the agency does not respond at all, by law, it's deemed to be denied. So that is not going to fulfill that public trust that we've talked about earlier. It is how the law operates. From what I've seen over the years, if a deadline comes and goes without a written response to the agency, it's because something has been missed somewhere. In which case, if you're the requester, you know, I'm not going to say it's my advice, but I will say I have seen it be successful to simply follow up with the agency and say I submitted my request on X date and haven't heard anything. More likely than not, the response you'll get back from the agency is, I am so sorry that we missed that, we'll get right on it, right? Versus contacting the agency and telling them they're in violation of the public records law, because unfortunately, technically, they're not in violation of the law because the remedy is it's denied, but that may not be what the agency intended. So generally, what you're going to see is an agency respond in writing to every public records request. And that written response has some requirements to it. And the first one being, if you're going to withhold or redact or deny a request, you have to point to the very specific provision in the law that allows you to do that, okay? And if you've done this for a while, that's definitely not hard. You're probably going to have form letters that handle most of this. But if you're not going to give something to the public, you've got to point to the specific provision that allows you to not do that, okay? You've also got to include a line about having reviewed it with an attorney. And again, this is in the context of if you are withholding in whole or in part responsive records, okay? If the response is it's day 2 and here's your responsive records, we've not withheld anything, that's great. That production can just go and you don't need a big long letter explaining why you're fulfilling the request. It's when you're denying the request in whole or in part that you got to get a little bit more specific. You got to include those statutory citations. You got to make reference to at least the opportunity for attorney review. It's not required. And then you also have to let that requester know what their rights are under the law in terms of appeal and the time period for doing that. Okay. I think I made brief reference to form letters. This is one where I've seen agencies have a lot of success, working from a form letter. That way, every time you're doing a redaction or partial denial, you're not reinventing the wheel saying, what do we need to include? What's the code citation? Those kinds of things. So again, form letters can be an agency's friend. There are numerous exemptions in the Public Records Act. Your agency is not going to work with all of them. So as you get more experience in this field, and again, I guess I'm speaking to those folks that work at public agencies, get familiar with the ones that will apply to your shop. If you're a requester, right, you're probably not going to know what the exemptions are, which is why the agency, if they're going to withhold something, they've got to point you to the law that they're using to do that, okay? These slides are really sort of just to touch on some of the exemptions out there, to just sort of show the audience, so to speak, that yes, public records is a very broad category, but not everything gets produced. And hopefully some of these exemptions will show you that that's kind of for good reason. First example there is essentially a bunch of attorney-client privilege communications between public defenders and their clients. So that should be a pretty straightforward example of something that should not be available to the general public. Social Security numbers. I think everybody can agree that the public should not have access to everybody's Social Security number, right? You got to submit your Social Security number to DMV, Fish and Game, numerous other places in state government. If you want to access a particular service, that information should be protected, right? Another important, perhaps maybe one of the more important exemptions is this exemptions in other state or federal laws. Now, for the most part, the exemptions to the Public Records Act are contained within the Public Records Law so that constituents aren't forced with running all over trying to understand what they have access to and what they don't. Here, the examples that come to mind for me are, FERPA, protecting educational information, perhaps HIPAA, depending on what kind of public agency we're talking about, and attorney-client privilege. You won't see attorney-client privilege spelled out specifically in the Public Records Act, but it certainly applies nonetheless, piggybacking on some other statutes. Betsy, I'm counting on you to tell me if I'm behind schedule or not. Because
You're
while I
doing
did set my
just
phone up
fine.
here. Doing all right? Okay. I did set my phone up here, but I did not take note of when I started. So, a couple more exemptions to note. Trade secrets. This isn't applicable to certainly every agency, but if you find yourself using a trade secret exemption, it's one that requires, agencies are best served by giving a little extra attention to a trade secret exemption. More often than not, it's to protect the trade secret of a third party. And in my experience, those third parties are pretty quick to say everything they have is a trade secret. And that's not always the case. So you need to vet that a little bit and just make sure that you don't put your agency in a tough spot protecting somebody else's information. Okay? And we'll probably get some questions on other exemptions at the end here. Quick slide on, we've titled it Access to Exempt Records, but this is really talking about when the requester is looking for records about themselves. And in that instance, the rules apply a little bit differently, right? Social Security number is a good example. You probably already have it, right? But if you are the requester, you request a bunch of documents that pertain to you, the agency does not need to redact your Social Security number because that's information that's unique to you. You already have it, right? And again, there may still be some other things that you can't get even about yourself. It's going to be very kind of nuanced. And again, when those come up, work with your legal counsel, work with your agency head. But I think the purpose of this slide is just to really highlight that when you're looking for records about yourself, it's a little bit different ballgame than when somebody else is perhaps looking for records about you. Okay, so proceedings to enforce the right to examine public records. So this is a topic that gets a lot of discussion, at least in the circles I run in. In Idaho, your sole legal remedy, if you're a requester and you submit a request and something gets withheld or redacted and you disagree, your only legal remedy is to go to district court. And I think a lot of folks, maybe that sounds a little bit harsh, but I guess I would offer as a practical matter, I've seen folks have plenty of success going back to the agency and having an informal exchange about why something was withheld. At the end of the day, you still might not agree, but just because going to district court is your only legal remedy doesn't mean that a requester can't follow up with an agency and say, this doesn't seem right, I don't understand this, and at least have some of that discussion. Maybe they submit a revised request, those kinds of things. Because going to district court's difficult, right? You're either navigating a space you're not familiar with or you are incurring the cost to hire an attorney, and frankly, nobody really likes going to court. So But again, that is the legal remedy. It's got a timer on it. You've got 6 months, you got 180 days. So track those. If you're the agency, right, and you've made a production and you've withheld some of it, probably want to hang on to that until that 180-day period runs, right? So, and the reason I say that is because if there is a challenge or an appeal, you're probably going to be in a position at some point in front of a judge, and you're going to want to be able to show your work a little bit and say, here's the whole stack, here's the things we withheld, judge, here's the statute, why, okay? So whether it's the 3 days, the 10 days, or the 21 or 35 now on the front end, or the 6 months on the back end, you'd be well served to kind of keep track of those calendar dates as you make these productions. If you do go to court, you're essentially asking the court to order an agency to produce the records that you didn't get, okay? Injunctive relief. Courts aren't going to award a big damages claim in these types of cases. It's either the records were properly withheld or they weren't properly withheld. Now, there is a little bit of an exception to that. We'll talk about in a couple of slides about bad faith. There can be some civil penalties for public agencies if you act in bad faith, right? If you just blatantly disregard the law. Surprisingly, courts aren't going to like that. So, let's see. And again, just kind of going back to that order of the court, it really is going to be narrow. If someone is challenging not receiving certain records, the court is just going to look at whether those records were properly withheld or if they should have gone. And that's what the scope of their order is going to be. There is at least the opportunity for costs and attorney's fees to the prevailing party in these cases, but that also has to be a showing that, the matter is frivolous. And that's a little bit of a high standard. I haven't seen a ton of attorney's fee awards in these cases. Plus, these cases are a little bit rare, in the first place. So, but again, this is a training. It's supposed to be informative. It's supposed to get things on your radar, have you thinking about these things as you go along. So those are at least the possibilities. I think I've only got one last slide here, just mentioning a couple miscellaneous provisions. The bad faith penalty if a public agency does disregard the public records law blatantly and a court says that was bad faith, there is a $1,000 civil penalty that can be assessed. It's probably going to come out of your own pocket depending on the agency you work for. The other side of that coin is there's an immunity provision. If a public agency produces something that they should not have, if they acted in good faith in doing that, if they go to trainings like this, if they're familiar with the public records law and something still gets produced that shouldn't, okay, people aren't going to jail, right? There's an immunity provision there, but you may not be the most popular person with your bosses, but again, there's at least an immunity provision. And mailing lists we have on there again, but like I said, we could talk about mailing lists for a long time, so I'm going to leave that alone unless we get a question on it. So that takes me to the end of what I've got, Betsy. So.
Well, we have already received a ton of questions online, but I would like to remind all of those in the room that if you have questions, please write them on your card, hold it up, and a volunteer will bring them up to Brandon and myself. We are the moderators, and we will pose your questions to Andy. So we're going to go ahead and start off with Brandon with the first question. But before he goes with that, I want to mention one more thing. And Andy, I hope you will agree with me that courts in Idaho have consistently found that all exemptions cited in the Public Records Act must be narrowly construed. These are not broad categories of exemptions. They are very specific. And if the request doesn't fit that exemption, the agency may not deny it. Is that correct?
Agreed, right?
Okay.
And you see similar stuff with the open meeting law, right? So narrowly construed is a popular phrase when it comes to government transparency.
Thank you, Your Honor. Brandon?
Andy, one of the first ones I want to kick off is, do text messages count as public records? And if so, have there been any cases where public officials have shared those text messages? And I'd also maybe add one other as a follow-up question on that is there a difference of having your personal cell phone as an official versus an office-paid phone?
Sure. So I'll do my best to address all those points, but when it comes to text messages, they are a writing, right? We have a very broad definition of a writing that we talked about earlier, but the key there is the text message, is the content of that text message being communicated for purposes of conducting state business. If it is, it doesn't matter what device you're using to do that. So whether it's state paid or personal, the key is, are you conducting state business? The other side of that, though, in my example with the spouse, maybe I do have a state paid work phone. If I get that text message from my spouse saying, please get something from the store, please pick up the kids from daycare, just because it's on a state device does not automatically make it a public record. Does that cover each of the points? Okay.
Absolutely. And one way that I've heard this phrased is that our public records law is content-based rather than platform-based. So if the content is about the public business, doesn't matter what platform it's on, it's disclosable.
Absolutely. Agree 100%. And I know the question was about text messages and cell phones, but the same would apply to email addresses. So if you have a boss or a coworker talking about, well, it's my private email address, don't worry about it, you need to have a conversation with them.
All right. Next question for Andy. Do redactions have to be made by an attorney? Can redactions be made by an employee who is not an attorney? 74102E only mentions redactions done by an attorney. What's the answer?
Well, it's a good question. The question cites the law, so that's a good one. I will say that over the years, I've not seen non-attorney staff do a lot of the redactions, but I'd kind of be hard-pressed without, I guess, researching it more to say unequivocally that staff cannot perform a redaction. If you're a non-attorney staff and you're looking at a social security number, I think you're a pretty good spot to go ahead and redact. So, and we get some expert testimony, I think, from the audience here. I'll go ahead and repeat it, but go ahead, Mike.
That was my comment. You don't need to be an attorney to redact a social security number.
Yeah, yeah.
So I'll just repeat that. Mike Gilmore in the audience said you don't need to be an attorney to redact a social security number. And he's been before the Idaho Supreme Court on these issues many times. So thank you, Mike.
Yeah. And again, I know we got to move on to other questions, but I suppose I would just offer there, it's really going to depend on the comfort level for that public agency staff, right?
Next questions, kind of group a couple of these into one here, is a lot to do with the new change with the out-of-state residency. What can a state or local entity do if a requester does not include their mailing address? And, for example, it comes in and just has their email address, I need this stuff. What can an agency or entity do?
Well, and again, this is a little bit of new territory, right? But the law requires not only the name, address, email, but it also requires that, essentially that affidavit or declaration about whether or not you are or aren't a resident. So if that prong is missing, then to me, I think an agency can look at that and say, this is an incomplete request. So until it's a complete request, we're not going to take action on it.
And just from a customer service standpoint, an agency would probably be well advised to get back to the requester and say, oh, your request is not complete because it's missing this item. Can you please send that before we can respond? It's probably not going to inspire confidence if the agency says, tough luck, you're never getting this record because you missed one checkbox. So customer service, that's a way to inspire trust.
And that applies the same regardless of any municipality, local government, state government, it applies the same, correct?
Correct. All public agencies would be similarly situated there on that one.
With regard to that new change to the law that passed last year regarding residents and non-residents. I've been asking around about how that's been playing out, and there are definitely some misunderstandings about it. And the law is not, the bill, it was not as clearly drafted as it could have been. I have heard of agencies saying, oh, this request is from a non-resident, so we don't have to respond. That is not what the law says. There are other issues with this. As written, when it says you have to attest under oath that you're a resident, pretty much the interpretation has been that the agency can simply have a checkbox in their public records request form where you check whether you're a resident or not, or in your email you can say, I am a resident of Idaho, I hereby attest, and I'm submitting this request. The sponsors of the bill, when they drafted that bill, excluded from their definition of residents not only those who haven't lived in Idaho for 30 days, but also anyone who's a part-year resident, anyone who's a full-time student in Idaho but has their permanent residence elsewhere, and a whole bunch of other things that are really too broad to fit within that 30-day domicile, so it's kind of contradictory. And part of the justification for that was, oh, well, those folks don't pay taxes. However, in 2023, 45,000 plus part-year Idaho income tax returns were filed in which part-year residents paid income taxes. So that is actually not accurate. And I personally think the legislature would be well advised to amend that law, make it a little more clear and a little more reasonable. If you've lived in Idaho for 30 days, you're a resident. Just editorial comment.
Do you want to ask the next one?
Okay. Thank you. How can the mailing list provision be enforced when it talks about their intention of what they're going to do with the records? So there's your mailing list question.
Yeah, I figured we'd get a mailing list question. So I think the way that I've heard this answered in the past is, again, it kind of ties in a little bit with the why. We can't really ask. Now, this is kind of one of the exceptions, right? If you have a requester tell you that they're seeking things to specifically use for a mailing list, they've kind of done your homework for you, and you're in a position to not fulfill the request. More often than not, it's not obvious, or a requester is simply not going to tell you that they're intending to use it for a mailing list. Rather than, spend 3 weeks as a public agency trying to sort this one out, I have seen agencies have some success with producing the records and putting the individual on notice in their response letter about the mailing list prohibition. Now, again, like I said, I think they've had success with that. I think as an agency, you're kind of fulfilling your duty there. But the mailing list has always been a strange one because a requester can develop their own mailing list through multiple requests. So there's a little bit of a blurry line, so to speak, too, on when does something constitute a mailing list and when doesn't it. So that's an answer that probably really doesn't help anyone with responding to that mailing list question, but it's one that I think, at least academically, gets a lot of attention in the Public Records Act. I don't know how much attention it really gets as a practical matter.
Andy, I'm going to kind of merge these three questions here. They're from the same entity, and it's a little different take, but it's still specific on records here. Can you explain in detail why it's important to have a records retention schedule, specifically for law enforcement? And if, for example, if an agency has an outdated records retention schedule that includes keeping all law enforcement records, what immediate action, if any, should that agency take?
Yeah, there are a lot of parts to that question. So I guess I'll probably just maybe respond a little bit more generally to records retention schedules. They're not necessarily required of all agencies. Certainly if you have one as an agency, you need to follow it and either retain or destroy your records on the proper schedule, right? And, for all public agencies, when it comes to retaining records, you can't be discarding records after the request comes in. So I think that's probably the thing that's more applicable to most. I know the question, I think, kind of presumed that an agency has a records retention schedule. Not all do. If there was more of a law enforcement component to that, maybe repeat it and we'll see if we can do anything with it.
Well, the question kind of along the lines of what retention schedule guidelines should agency use and where can they find them? Is there anything more that way as well?
What should their retention schedules be? That's an excellent conversation for the records custodian to have with their supervisors and their legal counsel.
The Public Records Act itself does not set retention schedules. It requires, so agencies are required to follow their retention schedules if they have them. If they don't have them, they just got to produce the records. Correct?
If they have an existing record, sure.
Yeah.
Yeah. If it's an existing record, responsive, not otherwise exempt, then it goes.
And as Andy mentioned, the worst thing an agency can do is try deleting a record after they get a request for it. That's a direct violation of the Idaho Public Records Act. The next question is, where the only recourse for disputes on public records between the requester and the public agency is a lawsuit, does the governor's office support adding a public records ombudsman or mediator to give Idahoans another resolution to those disputes?
It's a good question for the governor.
That means the governor's general counsel isn't answering that today?
I'm here as your tour guide for the PowerPoint and sharing my own views and experiences.
And we appreciate that.
Yeah.
Andy, do non-residents also get the 2 hours of free labor from the?
Doesn't appear that they do. They don't get the 2 hours free. They don't get the 100 pages. They also don't appear to get the lowest staffer rate. But again, there still is a cap on actual cost for the agency.
Basically, the non-residents have higher fees and longer period of time to reply. So if, let's say, you own a home in Idaho and you're here half the year and you want some information from your local city about your property, they can make you wait. But the other part of this is they don't have to. Just because agencies have up to a certain time period to respond doesn't mean they need to take the whole time. And to return to customer service, if you've got it there, just send it out. That's how we can all work together to make this law work.
And Andy, could an entity also have a different fee schedule for non-residents besides what's done for in-state residents?
Yes, under the new changes to the law, it does look like you can have a different schedule, but I'll just reiterate again, there's still going to be that ceiling of actual costs.
Here's a related question. Must the government agency have passed a fee resolution before charging a fee related to the Public Records Act?
No. Most agencies don't pass resolutions, right? Certainly boards and commissions might pass resolutions, but again, there are some defaults in the Public Records Act already, staff time. But certainly I know we've talked about in other trainings like this, right? We're at a point now where your copying fee schedule is probably going to be in the 3 to 10 cents a page maybe, and not the, $1.50 to, oh, we got residents, that's going to be $10, or non-residents is going to be $10 a page. Those are things that you probably want to give a lot of consideration to before you do that.
Andy, is the right to examine an absolute right? Can such a request be denied? And would an agency be responsible for segregating exempt records from a broader field of records?
Feels like a question Brian Kane might have submitted remotely. No, very few things in this life are absolute, right? So in our prior trainings, I know we've talked about if you have a situation where folks want to come in and examine something, if you know right off the bat that some of the responsive records are exempt, then you can withhold those from that stack of the other things that they're going to review, right? Or you've defeated the purpose of the exemption. Also, I know we've talked about in the past that needs to be done during normal working hours. It's a little bit of an unusual request, so it's going to have to fit into the normal business operations of the agency. Now, that doesn't mean an agency would be very well served, going back to the public trust and confidence, to say our next available time for in-person examination is in 6 months, right? So everybody needs to work together to figure out a reasonable time to have somebody come in. Also, the agency will most likely have a staff person in the room, because on the one hand, you have a requester looking for information. On the other hand, you have a public agency that is the custodian of those documents, and you're responsible for maintaining the integrity of those documents, making sure they're not altered or stolen or other documents put into the stack. So that's probably a little bit more than the question asked, but figured we'd touch on it.
So here's a very specific question, and this is from a city. Our data analyst would like to know if doing an SQL pull is creating a new record. If we do a manual export of data from another software program, is that considered a record or creating a record? How do we handle those? And how will we handle these kinds of requests? Do we deny or do we put them in another bucket to do later? And is that required? And part of what they're referring to here is the Public Records Act requires responsive records to be produced and turned over. It doesn't require agencies to create new records. But what about this SQL thing? What do you think, Andy?
Well, I was going to say you lost me at SQL. But I guess a couple of general comments. One, the time frame for your public records request can't be prospective. So when you submit your records request, it's going to be from whatever the front end date is that you identify, and then most likely, it can't go any further than the date of your request. Now, you could submit a new request down the road, right? So that doesn't fully answer the question about whether or not some of these reports are responsive records or not. But the other, comment I'll offer is the law is never going to be able to keep pace with technology. So Betsy's comment that an agency has no obligation to create a new record in order to fulfill a request, that was something I jotted down. I missed it during my presentation, but that's important too. So if you don't have a record, you don't have to compile everything in your shop to produce something that a requester is after. But going back to the technology piece, databases and things that are created, and is it a matter of a couple of clicks to generate a report? I mean, these are all things that I wish I had great answers for, but I go back to that initial premise that, I think we have photo stating in the Public Records Act. So, we're a little bit behind on technology advancement. So I think one of the themes there, though, is consistency. What are you as an agency doing? Goes back to your retention. What are you retaining? What's available in the first place? So it's always going to be a little bit of a challenge on some of the technology, but the best thing I think you can do there is have that conversation within your agency and figure out at least a consistent plan.
And also, if, again, from a customer service standpoint, if it would be so much easier to just do a few clicks and pull a report to respond to a request rather than produce voluminous things out of which the requester could pick this, this, and this, you might want to talk to the requester about whether they'd like to narrow their request to just that. And that way you can still be responsive. The next question is kind of the opposite. In this digital age, are government entities required to keep records in a physical file? Do we need to keep printed copies of our meeting agendas and minutes, for example, although we do post them to our website?
Yeah, I think in my experience, I think it's probably going to be really narrow in terms of what must physically be kept in a physical format. I think the vast majority of records are kept electronically now, but property deeds and some of those other kinds of things, there could be a unique exception for that. Not something that I've really dealt with. Certainly welcome any other thoughts folks might have in that arena if they've got experience with it. But I think the short answer is no, not everything has to be kept in physical form. Otherwise, these hallways would be full of paper. So.
Plus, we have that broad definition of public records in the Act that says any writing, the one that has photo statting, that says any form, even recordings, those are all public records.
Mm-hmm.
Andy, you talked at the beginning about specificity. That was the word that was going to trip you and me up. Is from the requester standpoint of sometimes I think it's an art of what we, speaking from the one receiving the request in our office, sometimes there's a big net that's cast to try to find something or something that's very specific. But if, in this question, if you request emails, do you need to specify who received and sent them?
So, classic lawyer answer of it depends, right? I mean, you don't have to be specific if you're willing to receive a voluminous production and perhaps pay for that production. But generally, that's not what folks are after, right? So you don't have to be specific, but I think I said specificity is your friend if you kind of know what you're after. So, but again, you can be as broad as you want if you're willing to wait and pay for it and then sift through it, I guess, once you get it.
And maybe on a customer service standpoint of reaching back out and saying, hey, being able to help, this is going to be large, it's going to take us some time. Is there maybe someone specifically you're looking for, or help trying to narrow that down and help be more specific to help on both sides?
Yeah, absolutely. And it kind of brings up another point that I should have talked about during my presentation, just on fee schedules in general or fee estimates. So, yeah, if you get a request as a public agency and you can see right off the bat that it's got a broad date range, it's going to be a lot of records, it's going to be voluminous, that's absolutely one to follow up with the requester on. Because you don't want to be in a position of producing, 25,000 emails and a big bill for someone that just goes, well, that's not what I wanted, and I'm not paying that. And now you spent a whole bunch of staff time gathering up stuff that nobody wanted. So having that conversation with the requester, do you want to narrow it? And even if it's narrowed, and this is the part that we didn't talk about, if you're going to request an upfront payment, that needs to be kind of, I shouldn't say it must be or it needs to be, but in my experience, agencies have had the best success with having kind of an itemized list, right? Here's your request. We think it's going to be this many records. It's going to take this much staff time to pull those. It's probably going to take estimated this much attorney time to review for redactions. So again, you've shown your work, and the requester at least knows where you're coming from, as opposed to just saying, interesting request, it's going to cost $10,000. Do you want to proceed?
Nobody likes to hear that when they've submitted a public records request. There is another way to be specific in a request for emails other than who they're between, and that's to request very specifically the topic or keywords that you want to search for. So again, going back to what Andy said about specificity, that's your friend. It doesn't have to be a particular thing, but the more specificity, the better. The next question here is, does the state have a template or suggested language for a disclaimer to notify our partners and contractors that all records relevant to conduct of public business are subject to the Open Records Act?
Not that I'm aware of off the top of my head, although there certainly could be some resources like that in the back of the Attorney General's open meeting or public records law manual.
And I would say that the question itself contains exactly all they would need to say for a disclaimer is to send something to all partners and contractors saying, warning, all records relevant to conduct of public business are subject to the Idaho Public Records Act and may be disclosed. And, it's pretty simple.
I think this is a great policy or kind of discussion thought on this one, Andy. Oftentimes, the Public Records Act is used to pry into the personal tragedy of a private citizen. It seems that the individual privacy interest could be asserted by an individual if they are aware, for example, in the Coburg case. But citizens don't know where their records are being requested. What will or can Idaho do to balance government transparency and citizen privacy?
Yeah, and that's an important topic and not one that I'm trying to be dismissive of, but it's really it's a legislative topic to sort of sort through, right? Because at the same time that we've not kept pace with advancements in technology, there could certainly be other interests that maybe aren't reflected enough in the Public Records Act. And I'm not saying they are or they aren't, but those are, just because we've passed the Public Records Act doesn't mean we shouldn't ever revisit it for some of those kinds of reasons.
Here's a question. What would you define as a non-reasonable effort? How would you advise we handle and fulfill a large volume of requests? First in, first out? Or is there another more appropriate way?
Well, certainly first in, first out. I think I've seen that as sort of the default for agencies, right? Because the meter is running, your 3 or your 10 or now your 21 or 35-day windows, right? So first in, first out certainly makes sense, but it's also public agencies have the flexibility to prioritize however they see fit, right? So maybe it's not first in, first out. You've got a real labor-intensive one coming up. and maybe that's where you want to dedicate your resources, that's fine, but you've got to keep the deadlines for all of your requests in mind as you do that. So does that get at most of the question? Okay.
This one, Andy, a little more specific here. Does the agency need to send the response with an attached response on the agency letterhead, or can the response be in the body of the email? Is there anything along the lines of
Yeah, I think it's
those ways?
dealer's choice. I mean, I've not seen anything to specify. I think you certainly want it to be your professional correspondence back, but I've seen much of this handled via email. But the same requirements apply in terms of if it's a denial, whether you use an email or letterhead, you still got to include those things that are statutorily required.
And I would say from my experience, many years as a reporter, I've received both compliance letters and denials in all different forms, and it didn't really matter as long as he got the point across.
Yeah.
Here's a question. When there is an active criminal case and the suspect and/or their defense attorney requests all records pertaining to their case, can we legally direct them to the discovery process and deny the records request under the public records law, or are we required to provide all the records?
Not being a criminal attorney and haven't dealt with that specific exemption, but based on what I've seen, I certainly lean towards that discovery exemption is there for a reason. I will say that I've seen agencies have a little bit of trouble with that sometimes when you want to rely on the discovery exception, which we didn't talk about it today, but there is an exception in the Public Records Act, or an exemption. You can't use the Public Records Act to circumvent discovery. But do you even know that there is a criminal case or lawsuit going on? That's point one. And then from there, and this is where we've had some issues over the years, has a discovery order even been issued? So just the fact alone that a case has been initiated, civil or criminal, you could probably ask 10 different lawyers and get a handful of different answers on when exactly that exemption begins to apply.
This is kind of a follow-up. This is interesting. Are records identified as exempt from disclosure in Title 74 that were created prior to the passing of the law, for example, draft legislation, are they still exempt from disclosure? In other words, does Title 74 apply retroactively to records created prior to the passing of the law?
Good question, not one I've ever, thought about. But I guess I would just go back to, is what you're asking for a public record? Is there an exemption applied just because the record was created? I still think that if there's an exemption for it, like draft legislation, it's probably still going to apply. But.
And on that draft legislation, I'd go back to that narrowly construed. It's not all draft legislation. It's specific draft legislation that is at there's very specific language about when the Legislative Services Office is drafting a bill at the request of a legislator. If a legislator has a draft bill that they have prepared, there's nothing to stop them from sharing it with people. That exemption way back when was described as covering everything that was on Myron Schlechty's desk, as I recall, because he was the chief bill drafter back then. But it doesn't apply to all draft legislation. Here is a question. Are quasi-government agencies like Idaho Housing and Finance, Boise City and Ada County Housing Authorities, or Southwest Idaho Cooperative Housing Authority required to fill public records requests?
Don't know about all of those in particular, right? But certainly it's a broad net for the Public Records Act.
And I would note that all through the Public Records Act, you will find references to, what's it called? Agencies,
Independent
body and politic. That's referring to exactly this type of agencies. And as a reporter, I have many times submitted public records requests to this type of agencies and have received very good responses.
Does HOAs included in that too?
Nope.
All right, just checking.
That is a question we often get at this seminar. No, HOAs are actually private. They don't have anything to do with the public records law.
I suppose they could opt in if they wanted to, but that becomes a contract issue.
Maybe a time check here. I mean, we're getting our great counsel and advice here from Andy. there's still a lot of questions, and we still have a lot here. How much longer we want to go, or we keep the
Let's-
meter running here
yeah.
with Andy and
If you're willing, Andy, let's take maybe 2 more questions.
Sure.
Okay. Let's see. How does a state agency handle a public records request from an out-of-state organization that advertises as "make your FOIA anonymously"? Can the organization make a request without identifying who the actual requester is?
I suppose there's a market for that. I mean, as far as I know, there's not kind of a straw man exclusion, right? I mean, and that kind of goes into the why. We can't really ask why someone wants a record. So could be interesting, right? If you see a public records request from the same business over and over and over and over and over on different topics, maybe that's kind of what they're up to. But again, it is someone asking for a public record. I tend to think there's probably nothing impermissible about it. Now, you can get into the whole, is this a resident or non-resident issue, but again, what somebody does with public records after they receive them from an agency, a little bit of their own business.
we have a lot of local governments participating, listening in, watching remotely. One of those, law enforcement is seeing a voluminous request, in particular on body videos being requested. It seems like even a request now is asking for it. Are there any discussions of changing the rules on how long an agency has to fulfill a request like that?
Not that I'm aware of, right? The 3-day, the 10-day, and the 21 and 35, those seem to be the standards that the legislature has put in place. I mean, it does kind of remind us of the earlier question about, you know, the retention schedule. So, I mean, that's certainly going to be important for law enforcement because, you know, you could fill up servers pretty quick, right, with the amount of body cam footage out there. But I'm not aware of an effort to change the response timelines.
And that said, the Public Records Act is very clear that all different types of writings or recordings are public records. And just think about all the things we've learned in recent years from seeing body cam video that the public's been made aware of, that it really needed to know. I want to thank Andy. We have grilled the heck out of him. How about a big hand for Andy? Well, I just want to thank you all for coming today in person or virtually. Thanks for participating. Thanks for caring about our laws and making them work. I want to thank all of our partners and refer you to our website, openidaho.org. A reminder on CLE, if you're an attorney, make sure you get that in. And you can see all of our sessions on our website. We do have one more coming up on the 27th, right back here in this room. And those of us participating as presenters today will be joined at that session by Brian Kane. And it will be about the Idaho Open Meetings Act. Thank you all. Thanks.